So, Bruce, there's been an immense focus on M&A related shareholder litigation in Delaware in the last year. How are these cases generally settled, and how do the judges respond to the settlements that are proposed to them?
Unfortunately, it's getting to be almost a dance. I think the statistics are something like 90% of public deals, there's a lawsuit within days of the announcement, if not the day of the announcement. I don't have a statistic that I know definitively is right, but 80 to 90% of them seem to settle within the period leading up to or at the preliminary injunction stage. Some of the plaintiffs' firms, they take what is almost akin to confirmatory discovery. They're not really trying to establish a case. After 2 or 3 depositions, send a letter saying, if you disclose the following things, we can settle. Defendants are happy to disclose those things. They agree on a MOU. A couple weeks later, they agree on a fee, anywhere from $200,000 at the low end to $600,000 or $700,000 at the high end. Goes to court. Court grits its teeth and approves it. And it just perpetuates itself.
And so even though the judges don't seem to like these settlements, they almost invariably approve them and approve the attorney's fees that are associated with them.
There'll be a lot of discussion during the argument on why this is a valid suit in the first place, how valuable were these disclosures, but at the end of the day, with rare exception, and there are exceptions, the court says, all right, well, it's enough to satisfy the minimum requirement for a settlement. And since the defendants aren't fighting the fee award, even though it might be more than I would have awarded had I had a opposition, I'll accept it. There are some that go over the line. The court carves them back. And there was one recent situation before Vice Chancellor last year where there was an objector who argued that the disclosure settlement shouldn't be approved. And after hearing the argument, the court disapproved the settlement. But in the absence of an objector, they pretty much sail through. Even though the court gives the plaintiff's attorneys a hard time, at the end of the hard time, the court approves the settlement.
And do you see anything changing, this dance, this pattern of behavior?
A new pattern is emerging, actually. The new pattern is the defendants will just make supplemental disclosure, not in exchange for a settlement, but in exchange for the plaintiffs withdrawing the preliminary injunction application. And then there really isn't a lawsuit left. The plaintiffs can dismiss it as moot or just dismiss it without prejudice on the basis that they don't feel like pursuing the case, and they apply to the court for an attorney's fee. And it's the same analysis as if it were a settlement, the difference being that the defendants don't get a release, of course.